Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. It's another drive across top of the state. Hey, we have been infrequently posting recently, and I'll tell you why. It has been absolutely crazy. There are some courts that have reopened, some courts that have not. I have a contract where I represent the juvenile office in a judicial circuit. And it has been insane. A lot of filings, a lot of cases. Once school came back in session, we're seeing a lot more referrals to juvenile authorities for abuse and neglect cases. Guys, don't beat your kids, please. It's really not that hard of a thing. Don't beat your kids, and maybe make them take a shower before they go to school. So today I'm not talking about a specific point of law, but rather more of a general thing. And we are going to focus this on the reaction people have with medical marijuana law. And the reason for this is our system allows people to defend themselves. And in fact, at times, it may even require them to defend themselves. For example, if somebody cannot afford an attorney, yet they're outside of the guidelines for which they can receive a public defender. There are, in Missouri, a couple of higher profile cases, and I'm not going to get into any details of those cases, where a person has been charged with a marijuana related offense and is not in a position to be able to afford to hire private counsel. And by virtue of some assets, they have not been able to get representation by the public defender. However, after several months of the process, that person has finally appealed their public defender denial, and I believe they were successful. Although, well, they said they were successful. The docket doesn't reflect that yet. But one of the things you have to pay attention to are that the system is not, judicial system and the court process truly is not the court of public opinion. It isn't a political process. It is a judicial one. Okay? There are a lot of excellent jurists of a particular political belief system that will rule in opposition of their personal belief system, because that's what the law says. So, letter writing campaigns to judges, yeah, that doesn't work. And folks, if you're not an attorney, don't file motions in a case, okay? Don't wake up one day and decide, hey, I want to support this person in another state and file a motion in their criminal case. It doesn't help. It makes it so much harder. If you are charged with a crime, you need an attorney. You need to be quiet about your alleged offense. Even if you believe that they are completely off base and they are completely wrong, you don't talk about it publicly. What you say if asked publicly is, this is a matter that's in the courts now. Unfortunately, as much as I'd like to talk about it, I can't discuss this until it's been resolved. Do not carry out conversations on Facebook about the alleged offense because all of that will become evidence against you. There are people that are charged with marijuana offenses across our nation, across our state, and the nation too, but we're focused on the state of Missouri. And across the state of Missouri, these marijuana offenses are questionable for people with a medical marijuana card. Okay? Every day we hear about another case. Somebody down in Pulaski County has a medical card charged with possession of marijuana. Somebody over in Chillicothe, somebody out in another area that's on probation, getting their, is facing a revocation proceeding and having their probation revoked because they tested positive for marijuana and they have a medical card. As I've said from day one, we cannot tell you exactly how it's going to come down until the Missouri Supreme Court rules on the interpretation of the law. Does the Constitutional Amendment say that you have a right to use medical marijuana? Yes, it does. That is the exact text of the... Well, no, that's a summary expressing the exact text of the Constitutional Amendment. You have a right to use medical marijuana in the state of Missouri. However, the Missouri Supreme Court has not interpreted the meaning of those words. Do you still have a right to use medical marijuana when you are on probation or parole? A commonly accepted interpretation of rights for offenders is that they have, by their own choice, sacrificed their rights. So, with that in mind, sorry folks. So with that in mind, the right that you have to use medical marijuana is not an absolute right. Can it be stripped away from you by judicial means? Well, any right can. Okay, your right to possess firearms can and is stripped away by legislative means, by judicial means. When you are on probation, when you're on probation for an SIS, suspended imposition of sentence, where there is not a conviction, you cannot possess or use firearms. It's one of the terms of your probation. So, that right, a fundamental right in our society, has been curtailed by judicial means. Can the courts also curtail your right to use medical marijuana? I would submit that they can. How they do that, when they do that, that is going to be the subject of clarification through litigation. There are going to be people here in Missouri that are going to go back to prison or going to prison in the process of us sorting this out. So please try to remember that just because the plain language of the law says something does not mean that's how the Missouri Supreme Court will interpret it. Case in point, the Firearms Amendment we had a couple years ago. The Missouri Supreme Court held that it didn't actually change the application of firearms law in the state of Missouri. And that's a very, very oversimplification of the case. But the essence of it is that the Supreme Court said, great, but it doesn't mean anything. which in and of itself was a problem. But this isn't about that. The point being is that until the Supreme Court interprets the law, we don't know how the courts are going to consistently hold on it. You very well may have differing results down in Greene County than you will have in Boone County. You may have a different impact of the law in Jackson County than you will in Adair County. And for those of you who are saying that that's proof the system is corrupt, it isn't. That's because the case hasn't gotten up to a controlling appellate court yet. And it's going to take time. Until it does, every judge is doing their own analysis and application of the law and making their own decision. Until the appellate court tells them, Eastern District, Western District, Southern District, tells the courts in their district what the interpretation is for that district, you may well have variations, even within a district. Once you have a Southern District and an Eastern District, or a Southern District and a Western District opinion, or Eastern and Western, they may be different opinions. In which case, we would want to go up to the Missouri Supreme Court to discern that, so we don't have different levels of justice across the state. But please understand that anybody who's saying as a matter of fact, this is what this means, you cannot, they just don't know yet. Lawyers tend to not say that directly. Okay? Actual lawyers will say, it's an interesting fact situation. Let's take a look and see how we believe the law applies. Or let's look at it and this is how we believe, but the court hasn't ruled yet. The facts are, we don't know what we don't know about how the court is going to interpret. Will the court interpret that you have an absolute right to use marijuana, medical marijuana, anytime you feel like, whether you're on probation, in the juvenile justice system, or on parole, or just happen to be, downtown Columbia? I don't believe the Supreme Court is going to go that far. I think the Supreme Court is going to say that there are plenty of alternative medicines that have been good enough for decades, and you don't have an absolute right to a non-prescribed drug. But I have my medical card. That is not a prescription. Until we can get marijuana removed from Schedule 1, you cannot have a prescription for marijuana. So, in regards to can you have your probation revoked, that is very much an open question. And it's going to have a different answer in different parts of Missouri until the cases get appealed up to the Supreme Court. How do the cases get to the Supreme Court? Well, you have your probation revoked and you appeal that decision. So somebody is going to go to prison and appeal that decision until we get an answer from the Supreme Court. Which means that you're going to have somebody who's willing to spend years in prison fighting this through the courts of appeals. I don't know who's volunteering to do that. On the next video, I may shoot today and post tomorrow, is going to be revisiting marijuana, medical marijuana, and firearms rights in the state of Missouri. And we're going to talk about that again. We've done it several times, but look, I'm a member on a lot of these forums and groups on Facebook and Reddit, and I have to tell you that a lot of the advice that's being thrown around there by non-lawyers and by some lawyers is wrong. And we'll talk about why I say that. So, thanks for watching. Please hit like, subscribe, Watch the whole damn video. I'll talk to you later.